Ishihara with the Ishihara and Parker Law Firm. Today we're going to be talking about how to plan for children with disabilities, those that are disabled children. Kristen, what exactly are we talking about? Who needs our planning?
Sure. So mostly, and this could relate in a ton of different ways to families, but mostly today we kind of want to talk to parents of children with disabilities. So your child was born with a disability, or maybe your child was in an accident or had something that caused them to have a disability, but now will require some special estate planning.
When you say disability, does that mean both a physical disability, a mental disability, a combination of both?
Sure, and that may depend on the family actually, but probably both. So specifically today we're going to talk about special or supplemental needs trusts. And those are absolutely critical. They're essential if you have a child who is receiving SSI or Medicaid benefits. You can't get away from them. You have to use them. There may be other times, though, when you want to use a special needs trust plan, even if your child is not on SSI or Medicaid, but maybe in the future, or has a physical or intellectual disability that causes them to need someone to handle it for them. So there's other reasons as well, but really what we want to get across today is that if a child is on SSI or Medicaid, this is an absolutely essential part of your plan.
Okay, well, why?
Sure, so good question. When someone is on SSI or Medicaid, they have a resource limit. And that resource limit is $2,000 in Texas. So if a child applies for SSI, maybe on their parents' record, once they turn 18, they can apply on their own record and be determined disabled. But that entitles them to receive an SSI monthly payment. It also entitles them to receive Medicaid benefits, which is really the more valuable part of that equation. But for insurance, once someone reaches a certain age, Medicaid is probably what they're going to need to pay the bills. So it's important to protect that benefit and not do something that would knock them off.
So, for example, I have a disabled child. They're receiving Medicaid benefits. I then, as I get older, I eventually pass away. I leave everything to my child, not understanding the risk that when I left my estate, my hard-earned assets that I want to pass on to my child, I will then cost my child those benefits. They will actually delay, they'll stop them, they'll reduce those benefits until the inheritance they receive is spent down. Is that right?
That's right, yeah. And sometimes it's done in such a way that isn't liquid, right? So there's a family farm and I've left my child an undivided interest in it. Well, that's going to be a resource that will deny them benefits but can't actually be spent to pay for the insurance or the care that they need. So it is really crucial that you understand how these things work together so that that child can be cared for at your death. And remember, too, that you can do this through a will that doesn't include that type of plan, but you can also do it by failing to plan at all. So if you die without a will, your child will inherit a share of your estate through just the intestacy rules of Texas, and that child would be denied benefits for having done so.
Right, right. So let's just start off with our easy, plain vanilla. Look, families are complicated, but let's just start off with an easy example. Husband and wife, married 20 years, they have a disabled child. Disabled child is going to grow older and continue to be disabled. Disabled child is going to receive Medicaid benefits, and they just want to do some general planning, right? They want to take care of each other first, and they want to make sure the child's taken care of best they can.
Sure.
What do we do?
Sure. So a special needs trust can be something that you set up now, or it can be something that you just set up through a testamentary trust included in your will. So in that scenario, it would be most common, I would say, to include it as part of your will because you really don't need to fund that trust until you've passed away. But let's say that the wills would say all to spouse, then when both of us pass, equal shares to all the kids with the child who has a disability to be held in a special needs trust.
Okay. Let me make sure I understand. So when we have just a normal situation with a plain vanilla family, husband and wife, married for a number of years, one disabled child, they can come in and they have a decision to make, right? They could say, hey, you know what? We want to create a standalone supplemental or special needs trust now, and we actually want to fund it now. Maybe we have a relative who wants to leave something or a third party wants to give something. This is a trust we want to create today. This is a trust we want to put money in today, and this is a trust they may even distribute in the future, in the near term, right? That's one method.
Sure.
The other method, and I think it's fair to say we probably see more of this, is where you've got a mom and dad, They say, listen, we love our child. We're going to make sure our child gets everything, but that child's not actually getting everything until we pass away, right?
Because you're providing for it during lifetime.
We're taking
So it's
care
just
of our
not
loved
necessary.
one. That's extra. So we do a basic will saying everything goes to spouse, and if spouse is deceased, then we have planned for that child in writing in the actual will, so they inherit, but they don't receive it outright. But if they don't receive it outright, I mean, how's that work?
Right. So with the trust, there are important decisions to make, and those are good things to talk about with the family. So just practically, depending upon the level of disability, you may be needing to consider who would be guardian or who would physically care for your disabled child. But then in addition to that, you're also going to need to select who would be the trustee. So who would manage the funds for them that are set aside in the trust. And the trust has some really specific, very technical, requirements, so that that's the reason that the special needs trust works. It is not to supplant, but to supplement what the government thinks that SSI is providing. And they think that the SSI check is providing for food and rent. So you cannot distribute out of a special needs trust for food, rent, or cash directly to the beneficiary. Those will still deny that individual benefits. So you do need a trustee with some level of financial sophistication. It doesn't have to be a professional, although sometimes this is a good opportunity to engage a corporate fiduciary who might have, experience with special needs trusts, but it can also just be a financially responsible adult child or family member or friend.
Yeah, so when it comes to serving as trustee, obviously a professional or corporate fiduciary, someone like that, they're wonderful. They're going to charge a set fee, but you'll know it'll be done correctly. If you appoint a family member, a trusted friend, someone reliable, they can do a good job too. Nothing saying they can't. It just takes someone with interest. I mean, they get basically a laundry list of yes, you can do, and no, you cannot do. And as long as they follow it, they act in the best interest of the child, keep good records. I mean, it's a doable task.
Absolutely.
Okay, good.
Absolutely. Yeah, I don't mean to scare anybody off. It is appropriate to ask, especially if your other child is going to be the guardian for that individual. Certainly is appropriate as long as they're a reasonable choice to make them the trustee as well. You want to have some backup trustee provisions. You also maybe want to allow for the trustee to appoint a successor trustee if they needed to resign. Just thinking through, because this trust is a lifetime trust for your disabled child. So, it may be a season of life for the trustee where they cannot serve. And so you want to build in some provisions with flexibility that would honor that you want them to make the decision, but allow them to put in place something so that if it's not right for them to serve, that you have some backup plans in there as well.
Okay, so I want to make sure I have this in my mind. Our standard, normal, easy couple comes in, married 20 years, they have a disabled child. They set up wills all to each other first. Upon death, it goes to our disabled child in a supplemental needs trust found inside our will. So the will is probated. It names a trusted family friend as trustee. That trustee or trustees are taking care of our child, protecting their welfare, protecting their benefits they're receiving from the government. And then, of course, I hate to ask this, but what happens upon, my child's death? What happens to those leftover funds if there are any?
Sure. So, and this is an important time to point out that there are some differences in special needs trusts. So if you just got online and Googled special needs trust, you need to be careful. This is what we're talking about today is what would be called a third-party special needs trust. That means that a third party set up this trust with their funds. It is not the disabled individual's funds. That would be through a first party special needs trust that we'll talk about in just a second here about the things to be aware of with that. But with a third party special needs trust, I can designate at my disabled child's death where any funds in the trust go. So I would likely say back to my other surviving children, or if they've passed, to their kids. But I get to say in the trust itself what happens to any funds remaining in the trust when my disabled child passes.
And the reason that's important is because as we know that when we receive government benefits, oftentimes the government says, okay, we will provide benefits to that disabled child, but upon their passing, any assets they have, we are going to take back for reimbursement. We would like to get paid back for those costs. If you plan ahead, if you've done it correctly and used a third-party special needs trust planning, either standalone or in the will, you will be able to avoid those payback provisions.
That's right, yeah. So what I think a lot of people don't, have a good understanding of is that you can leave assets to that child if you leave it in a third-party special needs trust, it does not count as an asset while they're alive. So it does not deny them benefits. And since it is not an asset that they own, it's owned by the trust and they are a beneficiary of that trust, it is not part of their estate at their death. So you are able to leave things to that child. One mistake that people often make is just cutting the child out entirely.
Yeah.
So maybe I've put my plan in place and I've left it to my 2 children without disabilities, and I'm relying upon them to take care of my child with disabilities. Have we seen that go wrong?
We have, and look, there are wonderful families and they have wonderful children, and we know why that was your plan, and we get it. But even the most wonderful children, siblings, have issues.
Get married.
They get divorced, right? They get
Yes.
married. They get divorced. They run a red light. You give them your disabled child's funds to care for a disabled child, other son or daughter, and then suddenly the good child holding on to money, the good child had something bad happen to him, and those
died.
funds are removed. Yeah.
They died,
Those
and
are
their funds
inheritance.
have gone to their minor kids. It's no longer available to
Yeah.
care for your disabled child. So you do,
Yep.
right, I try really hard to caution people about that.
Yep.
If you cut this child out, they do have to be able to maintain without any funds. Do not rely upon leaving it to somebody else and hoping that nothing happens to them so that they're able to do what you expect them to do with it. That is not a legal plan.
Okay. Let me give you another scenario. So this is one where they came in, they planned in advance, they took care of their documents, they thought about the future, and they protected their just disabled child and the funds from the government. Okay. We also see this, I think. Husband and wife come in, family member comes in because mom and dad have passed away, long-term marriage, they have one child, but they never wrote a will. They never did any planning. What happens then?
Yeah. So since Texas will write a will for you in that scenario, that will, assuming they were, all kids of the marriage, go to the spouse, and then in equal shares to the kids. Well, here's the problem with that. And also I'd like to interject that the same problem happens if you list that disabled child as a direct beneficiary, which happens a lot.
Yeah.
Even if you put that estate plan into place with a supplemental needs trust, you cannot list that disabled child's name as a beneficiary on life insurance, on a bank account. You cannot list them directly. So same thing happens if you don't have a will and now they are an owner of your estate. That is problematic because now they own the asset. The disabled individual owns it. It is not owned by a trust. It is owned by them. It is a resource that counts against them. They will immediately be denied benefits for being over-resourced. So what are their choices?
Well. So I like to recap just because, Kristen, this is clear. So what you brought up first was, hey, if you have a life insurance policy and you list a disabled child outright, we have problems.
Right.
If you have a will that doesn't have special needs trust planning, you have a problem. If you have no will at all and the state of Texas writes you a will, then you definitely have problems, or at least your child has problems.
Right. So in addition to having the will, you also need to make sure and correctly designate your beneficiaries. So it is not just have a will. It is have a will plus on your life insurance, say to Jerry, to Bob, to Joe's testamentary trust.
Yep. Perfect. Okay. Yep. Just want to make sure we understand. There's multiple ways to get in this problem. You can have the best planning, but all of your assets have to work together. You got to go through each one and think about it.
So if we have a client that has messed that up, what is the solution for the disabled individual that is now an owner of a resource that is denying them benefits? What can they do?
Seen this a bunch of times. So if we have someone come in who is a disabled child and they're inheriting from their parents and they have no will that we can fix, correct, or modify, and we're stuck with that situation, that disabled child, presuming they're under age 65, right, under age 65, can create what's called a first-party special needs trust. They can create their own special needs trust as long as they're under age 65, and of course we have some other downsides to that kind of first-party trust.
Right. So the reason the first-party trust works, and the government says it's okay for you to put assets that you own into a trust and qualify for benefits. I mean, because think about what they're allowing you to do. You have assets where you could pay, but they're going to let you put it into a trust and continue getting benefits. Well, why do they let you do that? They let you do that because a first-party special needs trust has what's called a payback provision. At that disabled individual's death, it will first pay back to the state of Texas everything that Medicaid paid out during their lifetime. So when you use a first-party special needs trust, the goal is to exhaust the trust during your lifetime. It is not to have funds left in there because you will lose whatever funds are in there. So it's beneficial because you can keep the trust, you can be the beneficiary as a disabled individual, but you do need to have it on plan to exhaust those funds ideally before the disabled individual passes.
The two trusts operate the same. There's going to be a trustee who is not the beneficiary.
Yeah.
That trustee is going to follow the rules of the distributions of the trust, which means we're not going to spend it on rent. We're not going to spend it on food in most cases. We're not going to give it directly cash to the beneficiary. Those things aren't going to happen. We're going to follow the laundry list of approved uses. But we know the downsides for a first-party special needs trust is, one, that person has to be under age 65 to create it. And two, we know any funds left in that trust at the time of death will be subject to clawback to be paid back for benefits paid for the disabled child.
Right. Not a good estate plan. Not a good way to leave your child, because you've basically, either denied them benefits or lost all the funds that you worked hard your whole life to build up.
Yep.
So it's a relatively, I don't want to say it's easy, but it's a relatively simple solution if you have the right information to get that done. But you can really mess it up for your child, who probably is relying upon other people to help in that situation. So in addition to, having some complicated plans that need to be put in place now for that child, dealing with keeping them on benefits, keeping them on SSI and Medicaid is just so hard.
Yep.
Very difficult.
Yep.
So really should be avoided if you can. But we see a lot of times, I think we've both had multiple clients where there was a will, and you can in Texas modify a will. So if I have a will that says equal shares to my kids, we can come in now and modify that share to leave it to a special needs trust for individual child. So even if an estate leaves out the special needs trust, Texas now allows us to modify that. But then the problem becomes, okay, I can modify estate assets being things that pass through the terms of the will, like the sale of the house, the sale of other real property, personal property, cars. But then dad has listed as beneficiary on his life insurance or whatever account all of the kids in equal shares. I've had multiple estates where now there's a third-party special needs trust that I've been able to direct estate assets to, but we've had to do a first-party special needs trust for the proceeds where the child was listed individually.
Absolutely.
Yeah, so it's possible. If this is done incorrectly, it is still worth coming and talking about what the potential solutions are, because there are solutions, but much, much better to do on the front end. Preventative would be much better.
Your disabled child would much appreciate you. You do the planning in advance, and they're forced in an emergency situation to try to save their own benefits in a very stressful situation.
Yeah, absolutely. What happens if you're over 65, Chris?
If you're over 65, you're unable to do a first-party special needs trust. So I've had clients come in before, they've inherited, and I said, well, how about some sort of spend-down plan, and what's the date on the calendar? Because we have to spend that money in the correct way for the correct things before the month is over, or there'll be countable assets, and you'll be denied your resources, denied your benefits because of your resources.
Yeah. It's a tough situation, tough conversation to have with somebody, because in theory, inheriting from a parent seems like a kindness, right? But now it's just a problem that's been dumped on somebody's lap that they're trying to clean up and deal with.
I remember a situation when I first started, called someone up, said, hey, I've got great news. Well, not great news. Your loved one passed away, but they made a specific request of $10,000 or $15,000, I think, in the will. And the recipient was actually quite upset. She's like, this is a real problem for me. I was like, well, why is this a problem besides you lost your loved one? She's like, I'm on benefits, and if I lose benefits, I will be in real trouble. It'll take me longer to reestablish my benefits, get my doctor set back up, get my housing going, than that $10,000 or $15,000 would ever fix. And until you see it firsthand, I was like, I'm so sorry. You're right. We'll have to work on that. But absolutely, very stressful for that beneficiary.
Yeah, certainly. So it is important planning. I do want to talk a little bit more about special needs trusts and what you can use them for, because I think that's a pretty common question. So we've said specifically you cannot distribute to the beneficiary directly cash. You cannot pay for their food, and you cannot pay for their rent. But let's talk about other things that you could do with the trust. So why then would I want to fund a trust for a disabled child? What could they use it for?
I always say quality of life. Does your disabled child need a vehicle? Gas in that vehicle? Car insurance? Stereo equipment? Medicines?
Yeah. Any medical care, any health care.
It adds... Anything that's not basically lodging or food, it adds so much to their lives, gives them opportunities to do things. What about schooling?
Sure. Could pay for education. It could pay for insurance premiums. It could pay for caregivers. The trust itself can actually own a house. The trust can purchase a car that would be in or out of the trust. But it can make major purchases. And sometimes you can use that then to take away maybe some regular bills like internet or phone or cable, things that can be paid for by the trust and then free up their SSI to pay for other things they might need. Yeah. But I would say a pretty common occurrence is to provide a house in some way for the child to live in, and then you remove the rent as a potential problem for having to pay for that.
It definitely eliminates the drag on life of just everyday expenses. Really free up that income.
Yeah. Certainly. The other thing I do want to mention there is just ABLE accounts. So sometimes if a child was determined disabled before the age of 26, they can have what's called an ABLE account. And a special needs trust can fund an ABLE account, if drafted that way, can fund an ABLE account. And the ABLE account is a non-countable asset for the disabled beneficiary as well, so it doesn't count as a resource for them. And it can be used to pay for food and rent and other things. So sometimes if there are, additional needs that are there, sometimes you can use a special needs trust alongside an ABLE account, alongside their SSI monthly benefit. The ABLE account, though, has a payback provision just like the first party special needs trust, so it is not an estate planning solution. You should not leave all of your funds to an ABLE account. It would be a mistake there, but sometimes you can pair those together and use those successfully.
And an ABLE account can give some extra freedom to the disabled child to handle their own affairs. ABLE accounts are basically bank accounts, I'd say, with restrictions that you as the trustee can set up. It can give them a little more freedom. It can restrict assets where it's used. It can allow it to be used certain places. It certainly gives a little more freedom to our disabled children when they're older if it's an appropriate tool. It does have its own rules, so of course be aware of what those are before you start putting money in there, but it definitely added flexibility.
Sure, and I did want to just give a brief, for trustees of special needs trusts, you can, through the terms of the trust, engage an attorney to give you advice. So I've recently here had several clients just in the estate planning process. They were stepping in now, dad had passed, and now they're serving as trustees. So they're the adult sibling of the disabled individual, and they're just trying to sort things out. So you can engage an attorney to give you advice on those things. Make sure you find one with specialized knowledge about special needs trust. This is not an everyday estate planning tool that every attorney would know how to advise you on. But like Chris mentioned earlier, we give a specific trustee instruction letter with listed out, here's things you can do, here's things you can't do. So those things are available. We don't want you to guess or be in the dark. You can, as trustee, engage an attorney to give you advice. You would need to engage a CPA to file a tax return because that special needs trust would have a tax ID. That's how you'd open an account in the name of the trust. It is not the trustee's assets. It is not subject to their liabilities. It is actually owned by the trust, reported by the trust, and then managed by the trust terms. So, anything else you want to add?
Nope. Just a little special planning when we have those loved ones who need some special needs. There's really no need to get it, not get it done. This isn't 30 years ago. This has been highly regulated. These things are developed. There's no reason not to get it right, really.
Right. Absolutely. Glad to help. And please share with a friend that might need this information. Thanks, guys. See you next time.